There is
Let me just, I'll get to one minute. Is there anybody that I have missed that wanted to be heard in opposition or in support of this nomination? All right, that being the case, Councilor Manning?
Thank you. There is another letter, I believe Council President just referenced it from a Jane Benner. And Mr. Cronin, is that letter in the file?
Which one do you have?
A letter from Jane Benner, BNR.
If it went to one of the individual councils, I wouldn't have it. If it went to the governor's council, I would have it. Do you have any idea what the date would be on it?
February
What's the 17th?
13th of July. It's right here on our desk.
It was put on our desk.
There's a fax from attorney, what was the last name?
Benner, BNR.
She's Councilor Kelly Simmons. When you got it? Well,
I think we all got a copy on our desk here in the council chamber this morning or whenever.
And I'd like to pass this down. We all got a copy.
I did not file it.
Could you put that on file then, Councilor?
For the record?
Please.
All right. We'll now proceed to questions by the council. Mr. Apter, I have a couple of questions for you. I think one of the issues that troubles the council is whether you omitted campaign contributions to Mr. Bonomo, his campaign, and to Mr. Marzilli's campaign because of their criminal predicaments and difficulties. You were acting to distance yourself in a way from them in an effort to not be straightforward and candid with the council. There's some concern that the two that are omitted are the two that are probably the most embarrassing, and is that too coincidental to be believable? So, can you address that question, please?
Thank you, Councilman. The donations that I made to those two individuals were legal donations. They were donations to candidates who, at the time I made the donations, did not have any criminal problems. They were donations which are matters of public record. I do not believe that there is a need to hide from legal activity or to fail to disclose legal activity. I don't have shame for having made donations. I made donations legal in amount to legal candidates running for office who had, at the time I made the donations, no known problems with the law, and in fact had solid records of performance in public service. I know that there are many others who made legal contributions to those individuals at that time, and I have no embarrassment about making the contributions that I made. There will be no reason to fail to disclose legal contributions that are a matter of public record.
Another concern that I believe is present is that you aspire to be confirmed as a judge, and one of the core responsibilities of anybody who sits on the bench is to interpret rules and statutes and cases and various other legal dictates and mandates, to do it in a thorough and cautious and careful way. Yet your approach to these questions in your form that you submitted to the council sort of doesn't seem to indicate that kind of approach to these questions, and I think it raises a concern about inconsistency from what we hear and what you said versus what you've done in this particular case. If you could address that.
During my 25 years of practice, I have not made a mistake with someone else's affairs or business, that is, clients or people whose cases were entrusted to me. In this instance, I made mistakes that were my own mistakes and were mistakes regarding my own affairs. I assumed that I knew more about my financial matters than I did. I assumed incorrectly and recalled things incorrectly. And that is far different from work on other people's matters. As a judge, I would fully understand that my responsibilities are to be extremely and totally attentive to the affairs of others, and not to assume that I know anything about their affairs other than what's put before me. In my case, I assumed that I knew about my affairs, and I made mistakes, and I made mistakes for which I have apologized, and for which I am sorry. But it does not happen with others, and as a judge, I will not do that. And I have learned a great deal from this experience and from these past 2 weeks. It was not the behave in a careless manner on the bench. I can assure this council and everyone in this room and everyone who comes.
Thank you. Again, keeping to the issue right now, earlier you mentioned, Attorney Aptaker, that when you went back to 3 years in your earlier comments, you said it said 3 calendar years. It doesn't say calendar years. I just want to be clear. It just says 3 preceding years. And it's just because I know you're making it clear, it says the 3 calendar years, but it does say the 3 preceding years. And so, again, I don't want to reiterate and rehash again what Councilor Merrigan said, but obviously we're here because there's about 3 months difference in terms, had you gone back for 3 years, one of the donations would have been in there, because it was only 3 months, it was September, and it was June that you did this application.
Yes.
It was like almost less than 3 months difference, and, I guess, integrity, honesty, I'm not, disparaging any of those, but a little common sense, is where I'm looking at here and saying, gosh, a couple of months, why don't I just put it in? Instead of being inclusive and exclusive. I'm here at the most important hearing, professional experience of my life. Now, you did also indicate that you asked someone asked you about that, or you asked someone. Could you just go over that a little bit?
Yes, I can. I turned in a completed draft to the JNC staff. They looked at it and said, you did not include the contributions, $100 contributions for 2007 grants. I explained that I did not list them on the form because they were too low. The JNC staff did not question my conclusion, so I assumed these did not need to be included. The error was mine. The mistake was mine, and I'm owning responsibility. I'm not putting that on anyone else. I asked them. They did not disagree with me. I took that to mean that I was correct. But I own that responsibility, and I agree with you, Council. In hindsight, I truly wish that I had been over-inclusive rather than under-inclusive. But I own the responsibility for the mistake that I made.
The other point related to the donation, I would say, campaign finance, hearing you said you weren't familiar with that website at all. Again, what I heard today was you went on and put in your city or town, correct?
Yes, after I learned about the website, I went to do it. And the first line at the top of the page asks for city or town, so that's what I put in.
Because you're right, I went on the front page of it, put an Aptaker, and everything came out, Bono, Mazzilli, whoever. They all came there again. I go, gosh, that's, common sense. Put in the name, look at your donations, and there it is. And I would just make a point, I don't know if Marilyn's here from the JNC staff or anything, but I would suggest that that be something that is asked of each nominee to go to OCPF, but nonetheless, it is a resource and a tool available to you, and you should have known. There's no question.
Thank you. And I agree. And I just want to remind you that for someone new to the form, the top line is town. The third line is name. That's not being familiar with the website. I went that way when I couldn't find it. Couldn't find the donation. That's when I did a little bit of experimenting with the website. But I thank you for your understanding of my lack of familiarity with that website.
And I'm not so much understanding because like one of your witnesses, the attorney who was with the JNC, he's seen hundreds of these, and in my 10 years, I've seen hundreds of them, and I don't recall, and I haven't done the research to prove it, but any time that we've seen this situation such as this, and again, the 2 donations would be 2 people who were recently convicted of serious, very serious criminal activities, that it just leads us to believe that there was a way to just keep that out of the way and not tarnish a potential review of your application and reputation. And that's what it appears clearly to all of us, I think, or most of us.
I understand that concern. I want to reiterate that the donations, I knew were public. The donations that I made were legal to legal candidates.
Absolutely.
And I made them before anyone had any inkling of their behavior going wrong. And I did not engage or endorse that behavior. So I would have nothing to hide. I would have nothing to hide and nothing to.
Our questions have nothing to do about your donation, appropriate donation, this is the disclosure. Now, I guess I go back to some of the things that Council I know raised, and people who've been in the court system, especially in the probate and family court, if someone come before you for, I'm sure you've been a zealous advocate, it appears for 30 years or so that you've been an attorney, given those few minutes to plead your case, and you're opposing person pro se doesn't have a counsel, and you are the counsel for the person for the judge, and they say, didn't have the information, look, he didn't put it in there, he's lying, my client, this is disgrace, you need to rule, you have the other hand to do those kind of things, and not, obviously that's your job as a zealous advocate, but the judge is sitting there, has so little time, and your credibility and your legal experience and resume is going to rise and go, gosh, right, look. And I guess the concern we have is for the people who go before the court every day, and there has to be common sense, not just legal acumen and smarts and all that. There's another, and good temperament, but there has to be common sense. And that is the human piece of this, that sitting on the bench that we hear about after decisions have been made on people, and you get nobody wants to talk, because attorneys don't like to bad mouth the judge, the fear of God in them, but they go, gee, so-and-so. What did you know? Everybody said he was great, and he's smart, and he's interesting, and he didn't have any issues. So can you be on that bench, really giving that compassion that's so important? And again, this is serious because it's such an important professional step on the journey, and it just has that appearance, and it's very difficult to look at that. We have marvelous witnesses, and I don't doubt any of them. I had calls, and obviously the whole word went out on the last week, and everyone running to your favor, and that was very nice and supportive, and I don't question your experience. But again, this is what we've been trying to get at today, and I'm going to take into account everything I've heard today, and I'm looking for the questions.
And part of that equation is human error. In this particular case, I agree with human error. As a judge, will I be more compassionate and understanding of people who make human errors as a result of this experience? Absolutely. Thank you.
I don't have any questions. First of all, Sandra, you're asking me to believe that you thought that 2010, take away 2008, equals 3. It asked you to list the donations of the 3 preceding years. Preceding means before, 36 months. Have you ever done these? Have you ever done these for 3 years? Isn't it 36 months? For preceding? I guess that, I just want to tell you, you're in a very unique situation. In all my tenure, that you're the first candidate that didn't know what 3 preceding years meant. And that's what's so troubling to me, because you're an intelligent person. These people here testing that you're an intelligent person. I wanted to ask you about the Somerville checkbook, because you're stating that you did not check the Somerville checkbook to see that John Bonomo, you were given to John Bonomo. How is it that you found Mike Capuano's contribution in that checkbook, but you couldn't find John Bonomo's in the same checkbook?
I did not find Mike Capuano's checkbook in that until it was called into question whether or not I made the donation. When I filled out my form to disclose contributions, before looking at any checkbook, I looked at my memory, and I thought, what contributions have I recently made? And I had recently made the Michael Capuano check donation, and I remembered it of recent memory, and I will tell you why I remember it. It was a very recent memory, as you know. It was after the beloved Senator Kennedy passed away, and it was the primary that Senator Capuano did. So it was in the past several months. And that is the only donation that I made of a political nature after submitting my judicial application. And so what I did was, before I wrote that check, to make sure that I was allowed to write that check, I looked at Executive Order number 500. Executive Order number 500 says you may make political contributions provided they're not to members of the executive branch or members of the Governor's Council. So before I made that donation, I wanted to make certain it was a legal donation. So I looked at Executive Order 500 when I wrote that check last fall, and I made the $100 donation. And I didn't need to look for that check because it was so recent, and that was in my memory for being recent, and because I looked it up, and because it was the check I had written after I submitted my judicial application. I never consulted my Somerville check registry.
Okay, first of all, you only gave to 9 politicians, not 20, 25, 9. You remembered a $40 contribution to a selectman, but yet you gave not just 1, but 2 to Bonoma, 1 before the 3 preceding years. So in total, it was $550. But you couldn't remember 2 contributions of $550, but you remembered a $40. And I'm thinking, how could you forget someone who went to prison? How could you forget that 2 contributions? Oh, the 2 contributions to Representative Manzelli, who left in disgrace from the Senate. Now, you don't have a crystal ball. You don't know what's going to happen, but it just didn't look good probably to put that in your estimation. It wouldn't have mattered. But you know, if you were concerned about those contributions, you didn't have to hide them. What you could have done was, you have a question, and our questionnaire that asks you to disclose anything, whether it's favorable, unfavorable. And you know what you could have done? Like many do, if you look up on the internet, you could have called the Manzelli Committee, you could have called the Bonoma Committee, and got your contributions back. But you didn't do that. And so now you have filed you have submitted a fraudulent filing. Okay? So, you know, the thing is that you don't think that 2007 is out of the 3 preceding years. I can't even address that. I don't know how you're counting. But I know if I ask a second grader to subtract 2010, take away 2007, they would come to 3. Now, you have been, you know, it's funny because I know the same thing that my counselor and colleague said. If someone came to court and I wrote this note and they lied about their income when they went to court to take custody for a child, would he be allowed to come back the next day and say, oh, I made a mistake and this is my amended income? No nominee should be allowed the right to amend such blatant omissions. And you know, your first questionnaire that you filed was under oath. You swore to the affidavit that this was true and accurate, and it was notarized. But now, you just the other day sent us a letter, and you submitted, not under oath, not signed as an affidavit attesting that it's all accurate and truthful, not notarized, and this is what we are asked to accept and vote. And, it's just incredible. It was the most simple question on that questionnaire. No one has ever got it wrong, except you. How do you account for that? That you could account for all of the others, these 2 people who have got into trouble. And there was no need to cover up. There was no need for it. And it's very important, truthfulness be the most important attribute of a judge. And you didn't know that this was public, and maybe you thought, it could be dismissed. I still go back to the JMC, the staff or whatever. You were asked about the 2007 contributions? Were you asked about that? Were you advised about it?
I was asked about it. I was not advised about it. They asked about the 2 $100 contributions in 2007. I had not included. I explained I did not put them on the form because they were too old. JMC did not question my conclusion, so I assumed that these did not need to be included. They did not advise me. They asked me about them.
Why do you think they would ask about 2007 if that wasn't the 3 preceding years? Why do you think they would even bring that up. Why would it be a question?
I can only speak for my company. I can't
But
say,
it
I
must
can't
have
say
been
what
an
other
issue
people
that it
did.
was the sin of omission. It has to be an issue that would be brought up to you.
That is your conclusion.
No, I'm not asking you, I'm asking you to ask why they were, I've never heard of this. This is the first in 12 years, I've never heard of this. This is what's so troubling to me. Because if someone lies, they're in contempt of court. I'm not a lawyer, but I understand.
I don't think a lot about that. When bad fortune befalls someone else, it's not in my nature to then add to that bad fortune by being a condition. That was money that's lost, it was money that's gone. I never even considered the possibility of this.
If it was not a concern of yours, you would have put the 2007 contributions when the J&C people asked you, just to say, okay, I'll put them in. But you didn't. And you'd argue the point that you didn't have to, because you didn't want us to see that. We don't have a crystal ball of knowing what's going to happen to people. And you chose that it didn't look good because you didn't want to put it in. There's no other, you know. I found no joy in requesting the governor to withdraw your appointment. I met with you, we talked, vice versa. I'm going to ask you, you know, when we came in here June 30th, June 23rd was your hearing, and then June 30th we came in and voted. And then when these things came up, then Council Merrigan asked it to be tabled. But the vote was going to be taken June 30th. Up to that date, that very day of the vote, June 30th, what councilors did you meet with, and what councilors called you to ask you any questions?
Prior to June 30th?
June 30th is the day they voted, and then it was tabled. So everyone would do due diligence up to June 30th.
I met with the councils who were present at my hearing, yourself.
My question was, who did you meet up until the vote, and who called you?
Who did I meet with personally was yourself.
That's right.
It's yourself. And I spoke by telephone with Councilor Callahan, who was my host council.
He was your host and told you that he wasn't going to make it, and that Council American would make it with each and that.
Oh, no, I spoke with him before he knew he was going to make it. I spoke with him a week before. I learned from someone else that he was going to make it. I don't recall who, but it was not Councilor Callahan.
Who else called you? Asked you questions.
I believe that was it prior
That was it.
to June 23rd.
That was it. So that was the preparation to vote for someone that's going to have life tenure, 14 years. And you know the most important application that you will ever do in your life. People lie about that they graduated from Harvard and say they're not easy. Who cares? It's not important, but it's those silly lies that people don't get a job, they don't get elected. It happens. It's happened in the past where a governor can't get a job. But I'm just saying that this is just not a mistake. It was intentional. There's no way that you can say that. But as I said, I found no joy in asking the governor to withdraw your appointment. And quite honestly, David, I was hoping that you would. I was hoping that you would. Because you won't accept, a judge wouldn't accept someone lying in court. How can I put someone that doesn't understand their own conduct and doesn't understand 3 to 7 years, 36 months? Thank you.
Yeah, thank you. Well, first of all, I was very impressed with the speaker you had come today to speak. And clearly you have been listening to the folks today, and you have an outstanding career so far. But I just have a few questions here. I just don't understand. It's hard for me to fathom that a staff member of the JNC asked you a question. It's almost like, what if they had said to you, you didn't list your contribution to Mike Dukakis in 1984. I know, I was. What are you talking about? What's that for? In other words, first of all, who was the person you spoke with, the staff person? What was the person's name?
I'm sorry?
Marilyn.
You know her last name? And what did she exactly say? Did she just say, will you tell me, what did she say this over the phone, in person?
It was a telephone conversation. She asked about the 2007, and I said that was outside the 3 years that I did. She did not.
Was that the only thing you had the conversation about? Did she call you or you call her?
She called me. There was a typographical error, spelling error on the name of one of the people that she was calling to.
Was that
So let me know. Yes, one of the senators I donated to, there was a typographical error on the first name. She was calling to let me know about the typographical error. And I believe there was a typographical error on the amount for Sheriff Apollo.
So she called you relative to the contributions you made. And then with respect to 2007, tell me exactly what she said.
She said that there are contributions from 2007 that are not listed on the form. I said I did 2010, 2009, 2010.
And did she tell you the names of those people?
I believe she did, yes.
So she told you 2007, she told you the names. Did she tell you the amounts too that you contributed?
I believe she did.
And that didn't, no response in your time? I just feel like the time would say, well, why, I don't have to put that down, it's 2007, that's not, I know you have to put 2009, 2010, 2009, 2008, that's 2007, that's not a valid question yet. That's why I think a reasonable person, you didn't say.
In hindsight, I wish I did.
No,
I made a mistake. I made a human error.
No, I appreciate it.
I wish I had.
And the other thing that troubles me, you indicate that most of the contributions you make, I think I read it here, that you make from your home address and house. But then somehow you remember the Capuano check, which was made out of your law office account. What I don't understand, when you were looking at your contributions, you can tell me how you do it. Did you go through your checkbook for 2000, I'm now talking the home checkbook.
Yes.
2010, 2009, 2000, is that how you did it?
Yes.
And what happened when you didn't see Capuano? Didn't you go, oh geez, maybe it's someone else, I better go back and check. I don't understand that.
I was looking for new information as I was going through the checkbook. I was looking for new information.
But you never saw Capuano there.
Correct.
Let me ask a real easy question, and maybe it's our fault. Did we not give you enough time? Is this a suggestion that when we schedule a hearing, you need 2-3 weeks? Did you get the feeling like I was pressured with this question? Because these answers are really tough to imagine. Tell me, is this like, oh, 1 week, give me a break, counsel, I need more. I wish I had 2 or 3 times. I think you put undue pressure on me. You give me.
I can tell you what else was going on at that time. And I don't want this to be taken as an excuse. This is an explanation of what else is going on. I accept the responsibility for this mistake. But this is what is going on. I had submitted a judicial application, a very detailed judicial application, a year earlier to the JMC. A year goes by, and in that application, they never ask anything about donations or contributions. On May 26th, I believe was the date, I received the word that I had been nominated as the judicial designee for the Middlesex County Probate Court. At that time, I was instructed that it's my responsibility to immediately, as a judge designee, withdraw from all of my cases because I, as a judge designee, cannot sit on the cases. And at the same time, I was given the form, it might have been a day or two later, given a form, and they asked to complete that by June the, I think it would have been the 15th. It was 8 days before your meeting, so 23rd minus 8, June 15th. So I now had about 2 weeks to do the following things. Withdraw from all of my cases, transfer all of my cases to new attorneys, and complete this form. Now, my priority in my life is to take care of the people who have entrusted with me with a fiduciary responsibility of their cases. I had a very busy law practice. I had trials coming up, pre-trials coming up, status conferences, meetings. I wanted to make sure that my clients were taken care of, that their cases were going to get attention during the time, that I wasn't going to be deserting them and leaving them in the lurch. I spent a great deal of that time immediately after my appointment attending to their needs. I should also have attended properly to did right by the other folks, apparently to my own detriment, and I have had a lot of time to think about that.
No, that's fine. So, in hindsight, if you were an advisor to the council, now think of what you went through. Because the next person who could come before you could have even triple the amount of cases that you have. Do you think we scheduled a hearing too soon? Which would have been a lot helpful, at least to you. Do you think you would have been more prepared with respect to the question if you had an additional week, or would it have made a difference?
I want to say at the outset, I don't presume to think that I can advise the council. I think that I have had enough problems in one of my duties that I don't think I stand in a position to be able to advise anyone. What would have been helpful to me, more so than anything, would have been on your question number 3, if it said, you can go to the OCPF website to find this information. That would have been most helpful to me because I was not familiar with that, instead of fumbling through check registers, even looking for where I had my check registers. If I had to make one change, that would be it, but I don't presume to tell people what to do.
So, my question is, if you had another week, would you think it would have made a difference, or you would have done it the same way? You would have omitted these, again, I know there's a mistake you indicate. If you had an additional week, I think it would have made a difference, the answer to those questions.
I don't know the answer to that. If I had another week, I don't know what it was going to be different. I think I would have been still occupied with doing what I was doing.
I can't, with all due respect, again, I mean, I know when I do my taxes, now, the quickest look at the firm, myself, I look through, I get my checkbook, I take it home, I look through every single check. It's hard to believe that you would miss that. I just can't envision myself. I don't know. It's hard to believe, like I said to you on the phone, I tend to give people the benefit of the doubt. It's really hard for me to believe that. Unless you said, I didn't have enough time, I didn't think it was a big deal, I rushed through it. Well, then shouldn't have done it. But that to me is more believable than yours, with all due respect. But put that aside. I have other questions. Can you give us then some shared parenting? You obviously know my position. Shared parenting, first of all, what does shared parenting mean to you?
Shared parenting means that both of the parents who are involved in the child's life should continue to remain involved in that child's life in a capacity similar to the relationship they had with that child before the separation of divorce. So to me, historical parenting would be the most significant factor to look at with regard to shared parenting. Let's try to make the change in this family structure the least disruptive to the child. Let's try to replicate the arrangement that existed before separated so that the child has the least trauma. And that could take many, many, many forms depending on what the involvement or relationship was before the structural fracture of the family.
I get a sense from so many people come to me, and the other councils will attest to this. I can't tell you the number of people who come to me, and they're mostly fathers. They come to me, they come before the council, and they say, hey, I got a house, I'm just divorced, I see my kid every other weekend, every other Wednesday from 6 to 8 for dinner. And I'm saying to you is, and this is what these folks say to me, these are other folks saying to me, and they say, Chris, can you do anything about it? I say, well, I tell them, it's not up to me. I'm not a judge. And they say to me, years ago, 30, 40, 50 years ago, most women did not work. And it's a good thing that women work now. That's good. They want to work, they want careers. That's fine. But when I lived in Jamaica Plain, as a young person going to the local school, everyone in that neighborhood, 80%, 90%, you come home from school, you see your mother, she give you a cookie, glass of milk. Now women work just like men work. But it seems like, at least that's, again, I don't do divorce, so you know better than I do. I've never done a divorce case. I'm getting the sense that even though times have changed, women maybe 30, 40 years ago didn't work the way they do today. The courts and the judges still give most of the visitation. You know better than I do because I don't do divorce. But most of the visitation goes to a mother. First of all, is that your sense?
Well, if I can just back up a little bit, because there are a lot of questions.
Sure.
The statute, for one thing, the statute talks about the presumption of equal, that the parents' rights are equal. It doesn't say shared, it doesn't say in favor of one or another. The parents are presumed to be equal. Now, what does that mean, presumed to be equal? They have the same claim with regard to the child. But being equal doesn't always mean things will be shared 50-50. Equal claim means that they both have the right to have some involvement and to do what they've done.
You know, I understand, but we'll have a meeting, what dentist you want to go to, what primary care you want to go to, what school you want to go to. I understand that, but they're not talking, we know this, I'm trying to get, and I'm familiar with the statute, let them to work. What's your sense of it? There are some judges who have the sense, you know what, if at all possible, I want it 50-50. There are some other judges who say, you know what, I'm the old school, the mother can provide better in the early years. I want the mother to have, physical custody, most of the time, maybe in a 14-week cycle, maybe 10, 11 days, the father every other weekend, and, and that in between. When I got to get a sense from you, what type of, I know what the statutes, we know what the best interest of the child or the children, we know that. But I want to get a sense from you. What is Judge Aptaker going to be? Is he one of those people who says, yeah, you know what I like? I believe the father can raise a child better. Or I believe a woman can raise a child better. Or I'm one of those who believes that, yeah, I'd like them 1 week with the mother, 1 week with the father. I'd like something. I want you to be as specific as you can, because we know the best interest of the child or the children. Well, what are you going to be if we vote to confirm you?
Let me tell you very clearly what my position is. My position is that the parents know best. The parents know best what is best for the child. And my first inclination at all times is to try to promote a settlement. That is to get them to make an agreement as to an arrangement that they think is best for the child. So my starting point is, let's do what we can to support a structure that allows the parents to make an agreement. Send them to family service, get a GAL to help mediate, get someone to help these people to talk about and work out the arrangement, because they know what's best for their child far more than I, a stranger, know what's best for their child. And I will tell you that in my experience of 25 years in this practice, that most of the time, cases settle and people work out an agreement. Part of why they work out an agreement are the people sitting in this room. They're good, solid attorneys who care about what they're doing and care about the clients, and are able to sit down and explain to the clients that the best way to promote the interests of their child is for the parents to work out an agreement. So having said that, I'm going to say that it's not always easy, but close to 90% or more of the cases get resolved and settle because of that understanding that parents know better. So now we're talking about the 10% or fewer cases where parents cannot make that resolution, cannot decide that. And you're saying that I should have a set, established, preordained formula as to what should happen in those very few 10% of the cases where the parties and the parents could not make an agreement. And I have to respectfully say to you that in those 10% or fewer cases, I need to hear what the facts are. I need to learn what the history and the particulars are. I need to hear from the people before I can make a child-specific determination. If I were to tell you now that I know what the answer is to those 10%, that would be unfortunate. If I were to tell you now I know what the answer is before I heard the evidence, I would do, in a sense, what I felt was happening to me 2 weeks ago. People trying to make conclusions about my situation before hearing all of the information. So with regard to that, I have learned a great deal over the 25 years, and particularly in the last 2 weeks. And I would not pretend to say that it's fair or right to set the formula for that other 10% of the cases in advance. The 90% of the cases that settle should settle, and I, as a judge, would do everything I could to promote the settlement, including bringing the parties in and educating them on the benefits of the settlement. I would do what I could to help the attorneys to get their clients to understand that. I will tell you one last piece of common knowledge from those of us in the field. The arrangements that work out the best, that have the most ongoing success, are those that the parties themselves have agreed to, not those that were imposed on them by the court. The reason is they have some investment in the arrangement working out, and they can make it work by their agreement. The ones that cause the most difficulty are the ones where a stranger did have to decide, because people resent that. And that's why some of the problems and some of the issues that come up in those cases. Those cases are very difficult and very troubling, and they come back to the court and back to the court because of that. So I would say that my biggest goal and agenda as a judge is to work towards getting people to resolve the case, starting with the notion that parents each have an equal claim, and the children benefit from that, and it benefits the most when the parents can work together, and that's our responsibility and our role to help them to work together when they can. But when they cannot, counsel, we need to make sometimes difficult decisions that are not always pleasant or politically expedient, but that the decisions that need to be made for the child based on that child's best interest. And I'm still willing to do that difficult work and still willing to take on that challenge, even though I've had some ordeal in the last 2 years.
Thank you. Let me ask this again. I'm not the best person to talk to when it comes to divorce law, because I don't do divorce law. This is supposed to come to me. When someone files for divorce, the average case takes about how long?
I don't know that the timeline starts to finish. I know that.
Ballpark, 25 years, a week? Give me a fair thing. I know you don't know exactly, you look at something.
Well,
If you'd ask me, don't do it, I'd say 2 years. What would you say?
Well, I don't want to split it. You're eliminating one age, a simple.
How about divorces where custody, visitation, and finances are an issue? I would say 2 years, but I've never handled a divorce case.
I would say average range would be between 9 months and 18 months. That's the range. It would sometimes go outside of that.
So if a case is settled, it could settle, with my understanding from talking to these lawyers, they settle at the doorstep, most of them.
Sometimes they settle in the courthouse.
Right. So when you talk about 90% of settlements, I mean, well, let's be fair. We're talking up to 18 months, using your figures, that visitation could be a huge issue. I don't know if you checked it, but the economy's really bad. It's real bad out there. Just in my neighborhood alone, I got about 8 people, either the husband, the wife, or both, unemployed. Did you ever think of a reason why people settle because they can't afford lawyers? Did you ever think of that at all?
Sometimes I'm sure economics are one. Sometimes it's
Not a major factor, though. Most people, if they want to fight over visitation, they can hire, what's a guardian, let me go slow. What's a guardian ad litem cost for an average contested divorce?
if the guardian ad litem is state aid, the guardian ad litem serves at a reduced rate of $50 per hour.
$50 an hour. And what is an attorney at law? Because that's also, they can have. What is an attorney at law to charge? And again, we're talking visitation and custody issues.
The range I've seen for attorneys at law, and that also includes psychologists and mental health professionals. The range I've seen range anywhere from $100 per hour to $350 to $400.
Okay, so you could have costs in a particular case, if one parent is contesting visitation, it could be in the thousands, just on guardian ad litem, attorney at law, and mental health experts, right?
Legal fees can be, legal and guardian ad litem fees.
I'm not even talking the lawyer's fees. Put that aside. I'm talking guardian ad litem, attorney at law, because you can have an attorney at law, okay, and mental health expert. Forget the personal lawyers of the individual. They can be in the thousands of dollars. Is that right?
Yes.
Okay. So when you say people settle, I can look around this room, including myself. How many people can afford thousands and thousands of dollars? And folks, I'm talking $10,000, $20,000, $30,000, $40,000 to fight for visitation. How many of you folks have that kind of money? Yeah, they settle out of court, but there's a reason they settle out of court. So when you say 90% of people settle out of court, they settle for a reason. But before they settle, a year and a half before, I don't know if you have any children, but for some of these people who come before us every week, it's important for them to know that they read a book with their son or daughter at night. They don't want to do that once every other Wednesday, or taking a kid to a baseball game, or taking a daughter to the movies. That's important. That to me is the most important job you have on that probate court. That's the #1 job. And to me, as you know, I'm an advocate of children's rights. That's all I'm about when it comes to probate judging. It's all about children's rights.
And I agree with you. That is how I entered this field of law. I entered doing children.
Yeah, but you don't have a sense when you said, I think a judge can have a sense my first reaction would be to give 50-50 parenting. It may not work in 90% of cases, maybe not 80, but I'm inclined to give you a break. May not turn out that way, but I start off saying I'm inclined to give this guy a benefit of the doubt. What I'm saying is, you have a difficult time, at least I'm getting the sense, to start off on a visitation case saying, I'm inclined to give 50-50 shared parenting. And the facts may not warrant that, because there may be alcohol issues here, there may be drug issues here, they may not warrant it, but that's what I don't get from you. You don't have that sense right off the bat, which I wish you did. Am I right, or am I putting words in your mouth? You don't have the sense that the children should have 50-50 visitation, custody. I don't even like using those words. You tell me.
I think that I responded earlier that I would look to the history of the child rearing.
No, I understand that, but you don't have the sense right off the bat. And before you get into that, I'm saying before you get into it, you're right. You're going to get into that history and this and what's this. I understand that. But before you get to that.
So my starting point is I would like to, in the beginning, have, before we get to a permanent resolution, in initial disagreement, I would like to find out what is the routine for that child and try to approximate an order that's as close to that routine as possible. My starting point is least disruption to the child. 50-50 may be a good starting point, but that may be extremely disruptive to the child. My starting point is the arrangement that's least disruptive to the child. And I'm wide open to a 50-50 arrangement if that is least disruptive to the child.
Yeah, well, whatever. I can't tell you what. Okay? The answer disappoints me, so I'll go on to my next question. The removal statute. What is the removal statute?
The removal statute relates to the legal standards that apply when there is a child whose parents are divorced or separated and they don't share custody. The removal statute relates to what happens when the custodial parent seeks to relocate and go to another jurisdiction with the child.
And under what circumstances? What's the criteria? Can I help with divorce? What's the criteria? Divorced people, they both live in Massachusetts, now one wants to go to Kansas.
The standard that's articulated in the honest case is what we refer to as the real advantage test. And what has to happen in that case is the custodial parent needs to establish, first of all, a good faith reason or motivation for the move. That is, they're not just seeking to go somewhere to deprive the other parent of custody. They're seeking, I did address this at the earlier hearing, there has to be a good faith reason. For instance, as you brought up earlier, the economy is in difficult shape. Some people may not be able to find work here, and unfortunately they have to relocate so that they can support themselves.
So let's go stop right there. In your opinion, the economy, you're 100% right, it's tough out there. We all agree with, everyone in the room agrees with that. So the father wants to move to Kansas because he had a job here, and now he got laid off, and now he's got a job in Kansas. Is that a good enough reason? That's the only reason.
You're asking me about the state of the law. Does the father have the legal custody in your hypothetical?
Yes.
Does the father have
He's
legal custody, and he needs to move to Kansas
For financial. And he's going to come in, I'm going to interrupt, but he's going to come in and say, I can give my son a better shot. I can even send him to private school. And it's unbelievable. I got a great private school, and it's going to be great. It's 10 minutes from my house. I'll be making so much more money. I'll be able to take him on vacation. Okay, now Judge Adams.
So he establishes a good faith motive for the move and establishes that, in fact, there will be a real advantage to him in making the move. And then we attach to that the logical corollary that a child will do best with their parent if their parent is happy and successful and doing well. If the parent is miserable and taking care of the child, that will impact negatively on the child. So what we say in that instance is, since it's a real advantage to the parent, since the parent will benefit, there's a benefit to the child that kind of attaches because of that, and therefore we will allow the move if those elements are proven. And that is another example of a very difficult case that comes before the probate and family court. Remember, the judges don't create the situation of the uncertainty or the difficulty. The judges have to then make a determination based on the facts that they're given as to how to best make that situation work for the child. And that's where we want judges who are compassionate, who are flexible, and who are understanding and respectful. But we judges cannot design, I should say judges in this system cannot create a solution that's better than the facts we're given. We can't make Kansas closer to Boston. So it's a challenging road.
Again, with all due respect, a judge can tell that father, you're not going to Kansas. And that's what I would hope that judge would tell that father, that he's not going to Kansas. Again, I don't know, do you have any children?
I do. I have two sons. They're adults now.
How do you feel when just think of it as a parent? Now you have two sons. They're going with your wife to Kansas. They're 4 years old, 6. How do you say?
I would be torn apart.
But I know you would be, but I'm saying, just that. How do you think those kids will be? They're not going to be with, like, well, let's go my hypothetical. They're not going to be with the mother. The mother's not going to be able to go to the movies, not going to be able to read books. I can't think of one good reason, other than a serious health issue, weather-wise, or some operation someone has. I can't think of one reason that it would be in the best interest of any children to have a parent move out of the state. Because you're basically saying, hey, guess what? You're never going to see daddy, you're never going to see mommy. There's no question about that. If you think otherwise, well, good luck. You're never going to see the person again. It's not going to happen. And then the kids are going to be brought up, the father's going to, in my hypothetical, the kids are going to obviously think, yeah, mommy never wanted to see him. That's the reality. So me, I can't think of a reason. The removal statute really troubles me.
I can't disagree with you. They are the most troubling cases that I have been involved in.
Tell me about video conference. You know the judge. You know the judge. I went to probate court. I saw her in the newspaper. Think of it, folks. Visitation by video conference. That's what we have in this state. Video conference. I'm 100% opposed to visitation by video conference. Tell me your thoughts.
I don't think that's the optimal way to handle it.
Well, I don't think anybody. I don't think that judge does. But under certain circumstances, you might order that. Under certain circumstances. I would never order it. But under some circumstances, you might be ordered that.
If I may pose the extension of that question, if they're living in different places,
Well, that's
is
the point.
the alternative no?
No, it's the alternative.
We want to encourage as much travel back and forth as we could. But if the alternative is no contact at all versus some form of contact, I would be in favor of some form of contact. And that's not to say that I'm endorsing that as the ideal situation. But please, Counselor, in these cases, we're not presented the ideal situation. We are presented dysfunctional families in conflict where people cannot make an ideal solution, and we do the best we can in a compassionate way to do the best we can with the imperfect situation that we have.
Yeah,
I wish that there were magic wands that could be waived, but there are not.
You know, in fairness to everyone else here, I could go on and on. I just want to make one final point here. I mean, I have so many more questions. It troubles me, and I don't know if anyone has any kids here. When people get divorced, I asked this to Judge Keary, judges have come before us, and they said, on a visitation, let's assume you have a 3-year-old and an 8-year-old, and these judges will listen 10 minutes aside, make your pitch. That's for weekly alimony, and that's where the kids are going. That's what happens on a temporary order when it comes to visitation. So you've got to get a lawyer who's like, oh my God, okay, 10 minutes, the clock's running. I think that's pathetic. Everyone says best interest of the children. You're an advocate for either one of the parents. You have 10 minutes to present your side for where the kids are going to live and how much you're going to pay your spouse. 10 minutes. Wow, either side has 10 minutes. Your thoughts on that?
I don't disagree with you.
It's awful. This system has got to change. 10 minutes? That's insane to me. Because what happens is most people don't agree. There's got to be some divorced people. They don't. The ideal situation, they all agree. It doesn't happen that way in the real world. So I hope you're going to be compassionate. You're lucky enough to be confirmed here. How do you deal with that? I know how I would deal with it. I mean, I've been asking you questions probably for way too long. Half an hour. I could go on. You're right, but imagine if the children were an issue, and they cut me off 25 minutes ago, you wouldn't say, oh, yeah. I mean, so these are issues that are really troubling to me.
And they're issues that I would pay a great deal of attention to.
I hope you would. And I apologize for taking so long. So I'm really passionate.
Councilor Manning apologized, she had to leave. Councilor Cole.
I'll answer your question right off the bat. I'm on number here. The problem is lawyers. How long does it take you to go through? I agree. I mean, I'm not an attorney, and I'll be open about it. You've all created it. Just to move on a little bit further here, I am irritated that we all have to be in this room right now. I said this in the beginning of our conversations with you also, David. The ball was dropped all along the road here, and all of a sudden it lands out here at our laps. Every question that these councilors have asked you, I've asked you on the phone. You know, in my 26 years in the state police, I spent a lot of time in court. I think there's attorneys in this room right now listening to your answers and saying, it doesn't sound good. It's tough. I don't question anybody, and actually, they probably look and get their hands on you a little bit better than maybe some of us non-attorneys might. I don't question your integrity, and I have a lot of respect for your witnesses in here. But I am questioning if this process was not given the due respect it deserved. You know, people want to talk about this council being a rubber stamp. Where I'm stopping at this whole thing is not necessarily David at David, but this is the last chance that anybody gets an opportunity to question someone before you become a lifetime judge. I'll tell you something right now. I'm upset right now that the JNC did not follow through like they should have. These contributions are not a big deal. And it's not the fact that you made political contributions. It's the fact that they were not listed when you asked for them, and they weren't there. I'm sitting here listening to other people on the phone calls I got over these past couple of weeks. Everybody says you're a man of integrity, experience, and you deserve to be sitting on that bench, David. But sitting here, if that information was presented in a court of law, with a jury sitting there or a judge, how many people in this room now, you can get over one thing, you can get over another, and you're asking us to make a big leap to get over everything. When the question was asked, as we said before, 2007, it is 3 years, and 2010 and 2007. JNC in the past, and Christine standing out there and so forth, you should have been advised to put every one of your donations that you've had on there. When I did the search, just like Council Philo said, the first thing I put down is that paper. JNC should have did that before you even sat down with us, or before you did. And everything would have popped up under F paper, not addresses, not different checkbooks, and so on and so forth. The other thing is, I understand you're trying to take care of your clients. But you're coming before us, and that application should have been a priority to you. You know, we're sitting here asking now, sitting on us to make judgments about credibility. I know if I came into a court, I learned very early in my career that when I go to court, if I was not prepared when I was testifying, I was willing to take a beating. I was going to lose my case. I learned early on to go to court prepared. You people are not prepared when you walk in here. That's why I'm irritated. This is additional hearings that we should not be sitting through because of carelessness. Not because you're not qualified, not because you might not be a man of integrity, but it was carelessness and it was sloppy work. Now all of a sudden, this governor's council is supposed to be sitting there. We're supposed to be making a judgment on your credibility and on the credibility of your witness here right now. I really don't have too much more to say, except that I am upset. And this is going to be a real struggle for me because, you know what? I think after 25 years, you ought to be judged on your qualifications. Some of the answers you said to Chris about your concern, I agree with. I agree with the fact that we're kind of stretching this whole thing up. It's not the purpose of me. I do think it ought to be 50-50 between the mother and the father. I feel very strongly. But the overruling thing is what is best for the child, period. And if there's an abusive father or abusive mother, we shouldn't just be giving them 50-50 because their father that's off to the side. You know, this is gonna be a struggle for me in the next week or so as to what I do. We've had long conversations. I'm not really satisfied. I'm not questioning her credibility. I am questioning the attention to detail that not only you, the JNC, did through this process. And what I'm questioning more than anything is, you know, have you people taken this process lightly? I'm not sitting here, and I didn't run for this position just because I'm going to go and say, yeah, it's okay. You know, come in here, tell us what it is, and okay, and if there's going to be problems, maybe not. But most of the time, I think the process is done correctly. In this case, there wasn't. That's where my concerns lie. So, as far as I'm concerned, I think you and the governor's office are asking a lot from us. What Council Viola said, and Council Devaney, and Council Ionella to agree. I have the same questions, you know, when I spoke over the phone. And again, I don't question your credibility. I wouldn't do that. But all the attorneys that are ruling during a court of law, and some of these same questions were asked. One may be okay. All right, now let's check. One will check the timing of the 2007, and if the JNC people saw that those 2007 checks and asked you why you put them down, you did make a conscious decision not to do that. You know what? They should have been put down. If there was a question in there, put them down. Who cares? You're not a mind reader about what's going to happen in the Mazilia one. That's not your fault that happened. You might have taken a little bit of questioning on regarding that, yeah, but it wouldn't put your nomination in jeopardy. So that's basically me spilling off because we've been doing this for 2 weeks right now. I've got a lot of people contacting me. This is the biggest part of my 4 years here that has been here, and I respect that. I'm not saying it's the biggest in here. Everybody's come to your aid and speaking very highly about it. I know you sit over it. I know this is difficult for your family. It's difficult for all of us. I am done. A little bit faster than the attorney that's over here.
All right, Councilor Crowley, just a minute, please.
Not to belabor this either, I think the bottom line, I think well said by Council Foley, between now and the time we make our decision, it's not going to be based on whether you're a great guy, you have 30 years experience, and you have a good reputation with your client. It's going to be based on what's happened in this process, I think, for me, that's what it's going to be. So to have 20 more people call me or send me letters, we're going to talk about you as a person. I think you've gotten that over the last hearing, information, and this. I think it really has to be that because, well, enough said. I think that's what it's all about. And I think Council Foley said it very well, and I appreciate that.
Thank you, Councilor Devaney.
Thank you. I just want to make a few points in what you did say, David. You never mentioned the conversation with the JNC in your written submission. And, you know, why should we believe that conversation with the JNC even happened? Second point, you implied that you were so busy you couldn't do a good job on the application that we gave you. But on question 6, you went back 23 years to 1987 and gave more than 30 examples of classes you took or taught. 3, you claim that the JNC mentioned 2007 donations to Mazilia, but not the 2008 missing donation to Phenomenal. So, I mean, you know, I'm not here to tell the nominees, make sure your questionnaire is right, go over every question. I meet with every nominee, and you know what they tell me? Marilyn, I spent 4 or 5 days over this. I went over every question, just double-checking. Most important thing in your life. And it's not my responsibility to call you and say, hey, is everything right? It's not my responsibility. My responsibility is to give advice and consent to the governor, not to this council, not to you, but to the public that I represent. That's my responsibility. And I'm not here to lobby for a nominee. I'm here to lobby for the public. And that's an awesome responsibility, and that's what I have to do. And I also want to say that some of you haven't checked your desk. You have got letters. And you've received another letter besides the one that was presented, I gave to George, and he's got one here today. But also, on 7/13, we got one from James Benner, and he is in the process of having a suit against you, which will be coming up the end of July. So you all have that, and you should have the council to put into the record. And, there's no joy in this, but this is very important, and, I've done my due diligence and reviewed all the information and the new information about the J&C conversation that you had. And, there's nothing more to say, and all I can say is very
Thank you. Real quick, I promise.
Yeah, right.
Yeah, real quick. It takes a lot of courage. No, just a second, this is important. It takes a lot of courage for people who came here to speak against you. That's tough. Can we get some type of assurance for the people who did speak against you and for the folks who wrote letters against you? If you're fortunate enough to be confirmed by this body, if for whatever reason they ever appear before you and they seek and they ask, request that you recuse yourself from the case, can we get assurances from you that you will recuse yourself from hearing the case?
Absolutely.
Thank you. Thank you very much.
All right, this is the conclusion of the hearing. I want to thank everybody, pro and con here, that's taken the lengthy time to participate in this process, and appreciate it. This nomination will be submitted to the council next week for a vote.
Thank you.